may I brief that facts on it? This is second round of litigation. Initially, we filed a civil revision, stay was granted, and thereafter it was disposed with the liberty. But the remedy would not lie in civil revision because it's not an eviction suit.
वो म्युनिसिपल कॉर्पोरेशन की अथॉरिटीज कहाँ है?
Yes.
बताइए क्या जांच की गई, कहाँ से हैं आप?
सीएमओ गोटेगांव निवेदन करी
जी।
एडिशनल चार्ज
सीएमओ गोटेगांव, आप बताइएगा क्या जांच है?
नरसिंहपुर
है?
एडिशनल चार्ज इन द
तो उससे हमें मतलब नहीं हो, तो सरकार ने बनाया ना एडिशनल चार्ज। जी अभी बताइएगा, नरसिंहपुर का मैटर है ना ये क्या जांच हुई थी आपकी इस बिल्डिंग के बारे में?
सर इसमें सर नस्ती का सर हम लोगों ने देखा।
क्या देखा था?
सर नोट शीट सर हम लोगों ने।
माइक का इस्तेमाल करिए, आगे आ जाइए।
सर नस्ती सर कल आई सर देखी थी
जी
सर, इसमें सर नस्ती में लिखा हुआ है
जी
सर नगर पालिका परिषद के क्षेत्रांतर्गत सर जर्जर मकानों का सर्वे सर स्थल निरीक्षण किया गया था, जिसमें सर संयुक्त टीम थी नगर पालिका की, राजस्व की, तहसीलदार की और आरई व पटवारी की।
किस प्रावधान में, कानून के किस प्रावधान में ये टीम गठित की गई थी?
सर आर्टिकल 221 में सर जर्जर मकानों के
221 ऑफ द कॉन्स्टिट्यूशन सेक्शन आर्टिकल बता रही है मैडम।
सॉरी सर
म्युनिसिपैलिटीज एक्ट।
हाँ दीजिएगा, म्युनिसिपैलिटीज एक्ट दीजिएगा। जी जी
2 and 3 लक्ष्य
है
221 लक्ष्य 2 and 3।
हाँ पढ़िएगा ना, तो एक से बताते जाइएगा। तो टीम कहाँ लिखा है इसमें कि राजस्व अधिकारी की टीम रहेगी?
सर ज्वाइंट सर्वे सर एक साथ हो गया था
जी, फिर क्या हुआ उस ज्वाइंट सर्वे में? फिर
उसके बाद सर पीछे सर इसमें 53 मकानों की लिस्ट लगी हुई है सर,
हाँ।
जिनको जीर्ण शीर्ण माना गया है।
हाँ किस आधार पे माना गया, वही तो पूछ रहे हैं आपसे।
सर ज्वाइंट सर्वे
आंखों से देख के आपको मालूम पड़ जाता है कौन सा जीर्ण शीर्ण है? कुछ तो एक्सपर्ट की रिपोर्ट होगी ना। इसमें इस टीम में थे आपके सिटी प्लानर थे, आर्किटेक्ट थे, सिविल सिटी इंजीनियर थे, बताइए ना इस टीम में कौन कौन था?
सर तत्कालीन एई किस तरह इसमें हस्ताक्षर।
यही क्या होता है?
असिस्टेंट इंजीनियर
हाँ।
टू द म्युनिसिपैलिटीज।
अच्छा क्या कहा उन्होंने, क्या क्या जांच की?
सर पीछे सर 53 मकानों की लिस्ट लगी हुई है।
अरे वो लिस्ट तो लग गई मैडम, ठीक है, लिस्ट तो जिसको आपने चाहा उसको लगा दिया। जांच करने के क्या पैरामीटर्स हैं? और फिर 221 में आपने नोटिस कब दिया? 221 में यू आर रिक्वायर्ड टू इशू नोटिस टू द ऑक्यूपायर। पढ़ा है ना आपने? 221 की नहीं पढ़ा? हाँ 221 में नोटिस कब दिया आपने?
नोटिस वाज सेंट लक्ष्य इन 27/5/2017 लक्ष्य
किसको?
टू द नेमली कामता पांडे लक्ष्य
2000
27/5/2017।
हाँ कामता पांडे कौन है ये?
सर मैं उनके लिए
हैं?
लैंडलॉर्ड है, लॉर्डशिप,
लैंडलॉर्ड है,
ओनर ऑफ द प्रॉपर्टी।
इसको नोटिस दिया आपने, ठीक है। इसमें नोटिस किसको दिया हुआ बताना बताया है? Why the danger is इतना put up issue and notice to the owner or occupier to put up इतना, the council shall cause notice in writing to be given to the owner or occupier। फिर first owner of take down, फिर कब हुआ? उसके बाद क्या हुआ? ये किस प्रोविजन में नोटिस दिया आपने?
अंडर द म्युनिसिपैलिटीज एक्ट।
किस प्रोविजन में? म्युनिसिपैलिटीज एक्ट समझ गए? 221 एक में दिया, 2 में दिया,
3 लक्ष्य
है 3 में नोटिस था ये आपका अंडर सेक्शन 221 ब्रैकेट में 3 ऑफ द म्युनिसिपैलिटीज एक्ट। फिर आपने कब इसको गिराया बिल्डिंग को? 2017 के बाद। फॉर योर फेलियर टू एक्ट इन अकॉर्डेंस विद द, हाउ कैन सब रेवेन्यू ऑफिसर पास एन ऑर्डर अंडर द गार्ब ऑफ सेक्शन 133 सीआरपीसी? और बताइएगा ना आपके खिलाफ क्यों नहीं कार्रवाई की जाए इसमें? यू हैव नॉट, in case of imminent danger the council shall have power without giving notice to demolish such portion of the building. When did you demolish it? From 2017. And why you were hand in glove with the owner and the occupier?
2013 में पहला नोटिस है।
चलिए होगा 2013 में होगा नोटिस, चलिए आपकी बात लिख लेते हैं 2013 में। फिर आपने क्या नोटिस दिया इन लोगों को, टेनेंट्स को?
लॉर्डशिप हमें तो 2017 में जब पहली बार
में पहला नोटिस है ना आपको, तो आप ही ने तो बताया बीच में कि 2013
affidavit, lordship, from the affidavit filed by tenants who are petitioner here, they have admitted that the property in dispute is in a dilapidated condition.
कहाँ है वो एफिडेविट?
Annexure P
2013 के नोटिस की डेट कहाँ से आई है मुझे ये बताइए।
affidavit sir lordship,
हाँ पेज नंबर,
ये पेज नंबर 29 lordship
29
of my return lordship,
आपका रिटर्न
lordship annexure
8 लॉर्डशिप।
एक क्षण रुक जाइएगा, देखते हैं आपका रिटर्न भी देखते हैं।
पेज नंबर 29, इन्होंने म्युनिसिपलिटी नरसिंहपुर के सीईओ को दिया लॉर्डशिप।
अच्छा, देखते हैं, चलिए।
एंड दे हैव एडमिटेड दैट द बिल्डिंग इज इन
क्या
डिलैपिडेटेड
लिखा है?
कंडीशन।
पढ़िएगा पढ़िएगा।
आई शुड रीड लॉर्डशिप।
हाँ,
समक्ष नोटरी नरसिंहपुर, पेश हेतु मुख्य नगर पालिका अधिकारी नरसिंहपुर सोनाबाई जैन एज स्वयंसो, मैं शपथ पूर्वक सत्य निष्ठा पूर्वक कथन करती हूँ यह कि शपथकर्ता गांधी वार्ड कंदेली तहसील जिला नरसिंहपुर की स्थायी निवासी है। यह कि कामता प्रसाद पांडे आत्मा श्री नवदा प्रसाद पांडे का मकान गांधी वार्ड कंदेली
तो आपने
नरसिंहपुर
खुद
में
affidavit
स्थित
दिया,
है,
एक माह में
जो
मकान
पुराना
खाली करने
जर्जर
के
है।
Let he complete. We have denied in specific reply. No such affidavit has been given. Nothing has been mentioned by the SD. This specific reply that no such affidavit has been given. He is relying on that affidavit which we have denied.
ये तो मुख्य नगर पालिका अधिकारी को दिया है आप।
हमने डिनाई किया in reply of the SDM that no.
आपके रिकॉर्ड में है ये एफिडेविट?
No, no.
6 एफिडेविट ऐसे हैं लॉर्डशिप,
अच्छा,
नॉट वन।
हाँ हाँ।
और इन्होंने इसी बेस पे सीएमओ नरसिंहपुर से claim किया लॉर्डशिप
तो
की
ये
हमें
नरसिंहपुर को आपको दिए थे एफिडेविट की इनको सीएमओ को दिए थे?
सीएमओ को दिया था।
सीएमओ की फाइल से दिखाए ना, सीएमओ मैडम तो खड़ी है ना सामने,
देखिए
उस फाइल से दिखा दें ये एफिडेविट कि उन्होंने दिए थे। जब आपके पास कॉपी है तो सीएमओ के पास तो होगी ही,
होना चाहिए लॉर्डशिप।
अनलेस आपने उसमें से निकाल लिए फाइल में से।
Something is favoring me, why should I?
नहीं, बताइए कहाँ है वो एफिडेविट?
In the my record, it is not.
तो फिर ये जवाब कैसे आ गया?
फर्दर लॉर्डशिप इन्होंने 18/1/13
Yes, yes.
को नोटिस एफिडेविट दिया
हाँ?
लॉर्डशिप।
One affidavit is here.
किसका है बताइएगा? नहीं नहीं, आपकी फाइल नहीं देखेंगे इस तरीके से वकील साहब।
Lordship, one affidavit is here, Lordship,
दिखाइए।
13/6/2017.
13/6/2017 का एफिडेविट ही तो है ये जो इन्होंने बता रहे।
Lordship.
हाँ, दिखाइए कहाँ है आपके रिकॉर्ड में?
इनकी फोटोकॉपी है वो जो इनने लगाई है केस में।
ओरिजिनल होगा ना?
नहीं होगा।
Original.
आपके अंगूठा निशानी की जांच करवा देंगे फिर।
तो डेथ हो चुकी है बहुत पहले, हमने रिप्लाई किया है। नहीं,
किया होगा।
that my lord can have the powers to do that. Here the case is that my lord under one they have when we were I was arguing on the point that 221 has not been followed. They come with the affidavit and reply that no, this proceeded under 133.
हाँ, तो ये जो नोटिस है 2017 का, ये दिस इज एनेक्शर 27/5/17 का नोटिस इज एनेक्शर।
नेक्स्ट It is an actual lordship at page 22 lordship of
your-
my return
ऑफ योर रिटर्न।
lordship page 22। सर कलेक्टर और जो डायरेक्टर टाउन कंट्री प्लानिंग भोपाल के उसमें ज्वाइंट उसमें सर्वे हुआ। सर्वे के बाद दे सर्व्ड अस नोटिस कि 3 दिन के अंदर आप मकान डिमोलिश करिए। ये 2017 में। बिफोर दैट आई वाज नॉट इन पिक्चर लॉर्डशिप, लैंडलॉर्ड वाज नॉट एट ऑल पिक्चर फ्रॉम 13 to 17, so 13 to 19। It is not that municipal corporation is working on our behest, lordship. It is the collector's direction. That's why the team of Tehsildar and SDM was formed, lordship. And it is their admission that इन्होंने इसके बदले में सर 2 मकान भी लिए, ये कहते हुए कि मकान जर्जर है और 10 दिन का हमें समय दिया जाए खाली करने के लिए। It is none of their case that house is not in dilapidated condition.
पढ़िएगा, अगला पेज पढ़िएगा जरा, पेज 23 पढ़िएगा। अनुभागीय अधिकारी क्या लिख रहे हैं प्रकरण दर्ज करके?
आवेदक कामता प्रसाद पांडे सजन सच के द्वारा अनावेदक दीपक ब्रजेश की मां सोनाबाई जैन से अपनी खानदानी पैतृक जर्जर मकान पुराना सजन सच नरसिंहपुर श्याम टाकीज के पास स्थित खपड़ेल व ईंट खपड़ा डबल स्टोरी में लगभग 80 वर्ष से अधिक पुराना है। आवेदक कामता प्रसाद पांडे द्वारा बताया गया कि उक्त मकान उनके नाम से दर्ज है, जो कि अनावेदक दीपक ब्रजेश से खाली करवाना चाहते हैं। उक्त के संबंध में आपके द्वारा आवेदक कामता प्रसाद पांडे निवासी गांधी वार्ड को पत्र क्रमांक सचन सच के माध्यम से नगरीय क्षेत्रों में खतरनाक भवन अथवा संरचना वर्षा ऋतु का प्रभाव संबंधी पत्र जारी किया गया था, जिसमें जर्जर की स्थिति में जानमाल होने रोके जाने संबंधी लेख किया गया था। अतः आप अतः उक्त के संबंध में आवेदक कामता प्रसाद पांडे के मकान मौजा कंदेली में पुराना वार्ड सच एंड सच नरसिंहपुर स्थित मकान अनावेदक दीपक जैन ब्रजेश जैन से तत्काल खाली कराया जावे, क्योंकि अनावेदक गण को दिनांक 17/9/2019 को समक्ष में समझाइश दी गई थी कि आप 1 सप्ताह के भीतर मकान खाली कर इस न्यायालय को सूचित करें, परंतु उनके द्वारा आज दिनांक तक मकान खाली नहीं।
133 के अंतर्गत ही एक्सरसाइजिंग पावर। तो ऐसा लग रहा है इसको पढ़ने से कि जो है मकान मालिक ने कहा कि हमारा मकान खाली करा दीजिए, ये खाली नहीं कर रहे हैं, ये आया है ना इसमें। उक्त तो मकान उनके नाम दर्ज है जो कि अनावेदक खाली करवाना चाहते हैं।
सर ये हम तो आई केम इनटू पिक्चर व्हेन नोटिस वाज सर्व्ड
ठीक है, ठीक
फ्रॉम
है।
द एसडीओ।
हाँ ठीक
आई नेवर वेंट टू एसडीओ लॉर्डशिप।
हाँ ठीक है।
और उसके पहले 2013 में सर इनका एफिडेविट पढ़ लें, उससे पिक्चर क्लियर हो जाएगा
इसकी
सर।
कॉपी तो आपको एंडोर्स्ड है कामता प्रसाद को। आप बोल रहे हैं आप यू नेवर केम इन पिक्चर।
I came in picture, Lordship, after this notice was served by the CMO Narsinghpur, Lordship.
On-
It is wide 25/5/2019.
अच्छा, तो इसकी
उसके पहले I was nowhere in picture, Lordship.
अच्छा, 25/9/19 को ये एसडीओ साहब ने पत्र लिखा।
जी, हमें कि आप 3 दिन के अंदर ये मकान जो है, मैं रीड लॉर्डशिप, पेज 22 ऑफ माई रिटर्न लॉर्डशिप।
आपकी अंडरटेकिंग फाइल कर दीजिए या रिकॉर्ड कर लेते हैं कि आप जैसे ही खाली होगा इसको मकान को तोड़ के नया कंस्ट्रक्शन करेंगे एंड दे विल हैव अ एंड इफ यू इंडक्ट एनी टेनेंट दे विल हैव द प्रेफरेंशियल राइट टू बी इंडक्टेड एज अ टेनेंट।
लॉर्डशिप,
ठीक है भाई।
जो लीगल राइट कोई इशू नहीं है लॉर्डशिप।
My lord, may kindly see there. It was a case which they have filed on 31/8/19. Again, he is saying that after September he has received the notice. He himself has filed a case on 31/8 before the SDM.
ठीक है, वो तो ठीक है भाई।
But my lord,
मुद्दे की बात यह है कि मकान जर्जर है, इसका नोटिस ऑलरेडी म्युनिसिपैलिटी जारी कर चुकी है 2017 में।
and we have filed the photographs that entire repair has been made. We have constructed the entire building properly. Photographs are already on record.
We'll not go into
My lord, may verify this.
under which authority you can construct it. Where is the building permit?
Repair, my lord, we have mentioned that we have repaired the
No,
house.
you cannot
It's a
repair it.
two-room house, my lord.
हाँ ठीक है, तो you vacate it. He will demolish it, reconstruct it. And
They have to proceed on the due process of law. They file a suit for eviction.
नहीं नहीं वो
Under
सब
133, my lord, they are, our own high court says that it cannot be done.
बताइए कौन सा जजमेंट है?
Now there are 4 judgments. And just pass on all the judgments.
आपने eviction का दावा कब लगाया है इनके खिलाफ?
Sir, we have not filed any eviction case, lordship.
You have taken a short circuit.
Not
Yes.
lordship. We came after the notice was served by the SDM कि आप 3 दिन में करें, otherwise आपके खिलाफ कार्रवाई होगी।
अच्छा अच्छा।
Otherwise we were not there at all.
Now,
हाँ हाँ
now demonstrate, my lord. Kindly see the case which has been registered under this provisions, my lord.
जी।
They have registered this case under 121B as per land revenue, my lord, circulars. my lord. 121B, it's the case number which has been registered by the revenue authority.
121B, yes.
Now, as per the circulars, my lord, 121 is the miscellaneous works of the SDM with the power can be exercised.
लैंड रेवेन्यू कोड में पढ़ रहे हैं।
नहीं, मतलब वो परिपत्र है राजस्व का। I will pass on this.
आप
परिपत्र।
दीजिएगा।
तो 121 जो होता है वो इनका मिसलेनियस रेवेन्यू अथॉरिटीज का वर्क होता है। व्हेन वी आर्ग्यू दिस मैटर, my lord, so please to direct कि इस प्रोविजन में आपने रेवेन्यू में किस प्रावधान में किया। They file an affidavit saying no, we have done in 133 of CRPC.
जी।
Turning, my lord, their stand of 121B की रेवेन्यू का नए स्टैंड लेके आए ऑन एफिडेविट की 133 में किया। So that's why I have supplied all these 4 judgments, my lord, that if they are giving an affidavit कि they have proceeded under 133 of CRPC.
जी।
My lord, first submission is that the same issue was there, my lord.
बताइए ना कौन से जजमेंट को रिफर कर रहे हैं?
मतलब सर,
बताइए।
फर्स्ट ऑफ ऑल, my lord, our own high court, my lord,
हाँ
वीरेंद्र कुमार महेश्वरी,
हाँ बताइए।
para 14, my lord.
पैराकोड।
It says for following the procedure of 133, 138 is very mandatory, my lord, para 14. After quoting these provisions, my lord, it starts with on reading of.
जी।
My lord, may just have a bare perusal of above paragraph of page 15, मतलब para 15.
पैरा 15।
पैरा 15 से ऊपर वाला जो पैराग्राफ,
जी।
मतलब 8th line onwards, मतलब 9th line, for the purpose,
इंटरनल पेज 10।
yes, my lord, 10th line, मतलब for the purpose of passing.
जस्ट अ मिनट। ऊपर से नीचे से?
ऊपर से सर, as in a summon case,
while passing an order, यहीं से पढ़ रहे हैं?
As in someone case,
आप कौन से पेज पे पढ़ रहे हैं?
वो पेज 10.
पेज 10 पर ऊपर से 10वीं लाइन तो है, while passing such an order.
11, 12, 13, 14th.
आप फिर आप गलत लाइन क्यों बता रहे हैं?
14.
For the purpose of
Of
passing.
passing such order under section 133, on receiving a report, the evidence is required to be taken as thought fit by the authority. In fact, it is an integral part and mandatory requirement of section 133 of Criminal Procedure Code. However, even for passing preliminary order, the procedure has to be followed. The procedure for summon case is specified in chapter 20 of the Code of Criminal Procedure under section 254 of Criminal Procedure Code. Thereby, magistrate shall proceed to hear the prosecution and take all such evidence as may be produced to support the prosecution allegation, and also to hear the accused and take all such evidence as he produces in his defense in the present case. While passing preliminary order dated so and so, asking reply from petitioner, 4 reasons were specified for the closure of nursing home. It is also observed here that the prior to passing the order, Annexure P6, the procedure as specified in the section 138 of Criminal Procedure Code has not been followed, although it is required to be followed mandatorily. In the facts of the present case, it is be further observed that the competent authority, while passing the final order 24/4/10, Annexure P1, has referred to the reply filed by the petitioner and specified that the oral opportunity of hearing was allowed, but from the order it is not clear that an opportunity has been given either to the prosecution to prove the allegation so levied against the petitioner, affording an opportunity of cross-examination of the prosecution witness, and also not afforded an opportunity to the petitioner to lead evidence in defense, which is requirement of summary trial so specified in section 254 of Criminal Procedure Code. Now, my lord, the second judgment relying on the apex court, the Kerala High Court, it says Devika Amma, my lord,
Yes.
Kachrulal Bhaginath Agarwal has been relied, my lord, para 11, my lord, running page 3.
जी.
May I read para 11?
Para 11. Yes.
It is very clear that the attempt of the petitioner is to evict the respondent tenant from his tenanted premise, the order for which should be obtained under the provision of Kerala Building Lease and Control Act. The sub-divisional officer relied on a report prepared PW2 Executive Engineer of Public Works Department to hold the building was in dangerous condition. The London Session Judge took the view that the report cannot be accepted. I have gone through the deposition of PW2. The report was prepared behind the back of the parties. Notice of inspection had not been given to either of them. The building was closed at the time of inspection. PW2 did not even enter the building. He did not ascertain the width of the wall of the building. He did not inspect the strength of the first floor of the building, nor did he do any scientific test to ascertain the stability of the building. In the report, he has not given any details of the inspection which is expected of an expert. Now, thereafter, relying on Supreme Court, the apex court has held the dangerous condition of the building is in present but not in future. This has been reiterated in Kachrulal Bhaginath Agarwal versus State of Maharashtra 2005 so and so. The engineer who inspected the property PW2 was of opinion that even a minor natural calamity would result in collapse of the building. The inspection was conducted in or about 2006. Even now, 2019, the building has not collapsed. So it was very immediately when this proceeding has to be taken. Now, even now 2023, the building is well. Now, imminent danger has also been relied by Kerala High Court. The third judgment is Balkis versus Revenue Divisional Officer.
जी.
Para 6, running page 3.
जी.
Now, further interpretation of public and private right has been distinguished. The nature and extent of jurisdiction of SDO under 133 have been considered by this court in so and so. The principle that can be culled out from the said decision is that jurisdiction provided under section 133 of CRPC is confined to public right only. It is pertinent to note that the cardinal principle that the first respondent gets powers under section 133 of CRPC only if a public right is involved has been totally lost sight of. Apart from this, the first respondent can exercise power under section 133 CRPC if there is imminent danger of the building or the construction is likely to fall or likely to occasion conflagration or explosion. But the third respondent has no such case, my lord. Thereafter, my lord, lower 5 lines, my lord, no such interpretation can be given to subsection D to redress a private grievance caused by construction without permit or made in violation of municipality building rules. I am of the. Now, my lord, last judgment is Bombay High Court, my lord, Peter Fernandez. Para 11, my lord. Again, Santosh Patil and Kachrulal Agarwal has been relied. The object and purpose has been mentioned. Thereafter, section 133, my lord, starts. As noted above, appears in chapter 10 of the code, which deals with maintenance of public order and tranquility. It is a part of heading public nuisance. The term nuisance, as used in law, is not a term capable of exact definition. It has been pointed out in Helsbury Law of England. Even in present day, there is no entire agreement as to whether certain acts or omission shall be seized, classed as nuisance, or whether they do not fall under the.
ठीक है
My lord. My last submission, my lord, para 16 of this judgment, my lord.
जी
It is also noted that the proceedings under section 133 of the code are not meant to settle private dispute between two members of public or members of two household, and for public authority to waste their time in settle such dispute. A magistrate under section 133 of code exercise a public duty, and he can exercise only when judicial facts are present.
जी ठीक है
My last submission is, my lord, section 5 of CRPC, kindly seen, and section 12 of Accommodation Act
सेक्शन 5
of CRPC.
सीआरपी एकोमोडेशन कंट्रोल एक्ट निकालिए इसका जी
5. Saving clause.
जी
Nothing contained in this code shall, comma, in the absence of a specific provision to the contrary, comma, affect any special or local law for the timing in force or any special jurisdiction or power conferred, comma, or any special form of procedure prescribed by any other law for the timing in force. Now, this saving clause has to be hit by section 12 of Accommodation Control Act. Madam. We'll start with a non-obstacle clause that eviction suit has to be filed by them for such dispute.
ठीक
Now, my lord, in the end, my lord, I only submit that in the reply we have specifically stated the building is not in a deprecated position. We have stated that it's in a complete proper condition. Photographs are already on record, my lord. It's a 2 rooms, completely, my lord, maintained by us, my lord. And last, that the affidavit has been denied. And we have taken a preliminary objection that you have to go before the Rent Control Authority, which has not been considered by the SDM in its order.
ठीक
No evidence has taken.
यस
I rest my.
As per Lordship, now the position is the building.
क्या है दीजिए ये क्या है पोजीशन ऑफ बिल्डिंग आज तो ठीक है आप ये बताइएगा कि आपकी जो टीम थी ये कब गई थी वहां पर अंदर कब गई थी मकान के जब आपने जांच की थी ना कब गई थी कब गई थी जांच करने के लिए आपने बताया ना टीम गई थी इतने सारे अधिकारियों की मकान कब देखा था भीतर से जाकर
Dated Lordship 24/9/2019.
अरे नोटिस आपने 17 में दिया और जांच 2019 में कर रहे नोटिस तो आपने जो है सेक्शन 221(3) का 27/5/17 को दिया था
Lordship.
बिगड़ जांच की नोटिस दे दिया था क्या जी कब जांच टीम कब गई थी डेट बताइए
Lordship, date is the Lordship 24/9/2019.
अच्छा एसडीओ साहब का ऑर्डर कब का है
That is
19/11/19
Lordship.
उसके बाद कब नोटिस दिया आपने 22/9/19 के बाद में This petition is filed by the petitioners being aggrieved of order dated 19/11/2019 passed by the sub-divisional officer within bracket revenue bracket close Narsinghpur and
May I
revenue
submit,
case
Lordship?
number 0129/B-121
So may I submit, Lordship?
2019 एक मिनट सुन रहे हैं आपको 19/19-20 मौजा कंदेली whereby exercising authority under section 133 CRPC, sub-divisional officer has directed the petitioners to vacate the premises. Full stop. It is submitted by Shri Ankit Saxena that sub-divisional officer was acting as a agent of the landlord and ordered for vacating the premises where without there being any decree of the competent court for eviction. Full stop. It is submitted that instead of seeking eviction as per the provisions contained in the Accommodation Control Act, comma, a short circuit device has been adopted by the landlord for seeking eviction. Next paragraph. It is also submitted that reference to the affidavit dated 13/6/2017 is bogus and none of the authorities have brought original affidavits on record. Even the private respondent has brought photocopies of the said affidavits without informing the source from where he has obtained such affidavits. Full stop. Placing reliance on the judgment of this High Court, on the judgment of this High Court in Virendra Kumar Maheshwari versus State of MP 2013 का एक क्राइम्स विद इन ब्रैकेट SC 309, Bombay High Court in case of Shri Peter Fernandez versus State of Goa and another 2007 का 3 crimes 642 Bombay. Judgment of Kerala High Court in Balkees BALKEES versus the Revenue Divisional Officer and others 2013 का 0 Supreme within bracket KER bracket close 315 and judgment in case of Devaki Amma versus State of Kerala 2019 का 0 Supreme within bracket KER bracket close 131. It is pointed out that the exercise of authority by the subdivisional officer under section 133 CRPC is uncalled for. Next para. Shri Ved Prakash Tiwari submits that notice was issued to the landlord on 27/5/2017 in terms of the provisions contained in section 221 within bracket 3 of the Municipalities Act 1961. Thereafter, a team of municipal officers and revenue officers inspected the locality on 22/9/2019. Thereafter, a decision was taken to order for removal of the petitioners. Next para. Shri
24.
Huh?
24.
20
4.
24 22 नहीं है 24 है
Lodge.
24/9 कर दीजिए 24/9 इतना. नेक्स्ट पैर. श्री Umesh Tripathi, appearing for the landlord on KV8, draws attention of this court to the affidavits filed by the petitioners as annexure R1/8, R1/9 to point out that there is no illegality in the impugned order of the subdivisional officer. Full stop. It is pointed out that a panchnama was drawn as contained in annexure R1/5 on 30/11/2019 declaring the building to be in a dilapidated condition and required to be pulled down, but since Shri Deepak Jain and one Shri Brajesh Shukla are residing in the house, it is observed that it cannot be pulled down. Next para. हाँ और बताइए अब आप.
Lordship, the case of petitioner is Lordship that I should move before the RCA for eviction as I am the landlord, Lordship. The reply of the reply annexure R11, Lordship, page 48 may kindly be seen.
R11.
My learned friend argued the same issue, Lordship, before the single bench, Lordship, when he has filed the order against the order.
Page 48.
48, Lordship.
8 of your reply.
43, Lordship.
43 of your reply.
Lordship.
चलिए.
In this, Lordship, third paragraph,
जी.
5th line, Lordship,
जी.
इस बाबत विवाद नहीं है कि 1990 के बाद से आवेदक तथा अनावेदक के बीच में किराएदारी के संबंध में किराएदारी के कोई संबंध न होने से आवेदक द्वारा अनावेदक से किराया नहीं लिया गया. इस प्रकार अनावेदक द्वारा लगभग 19-20 वर्षों से यानी 12 वर्ष से अधिक अवधि में मकान में रहने और अनावेदक तथा अनावेदक के बीच में किराएदारी के संबंध स्थापित न होने से अनावेदक का मकान में विरोधी अधिपत्य स्थापित हो जाने से मकान मालिक काबिल हो गए हैं.
डिविजनल ऑफिसर डिसाइड करेगा ना, हाई कोर्ट डिसाइड करेगा.
Lordship, what is their affidavit, Lordship? That's what I'm saying. Their conduct was they have taken the U-turn immediately, Lordship. ये annexure 8 देख लें लॉर्डशिप,
R80 तो दिखा रहे
उसमें ये कह रहे हैं कि मकान डिलेपिडेटेड है और हम किराएदार हैं और हमें
क्या है, वो तो एफिडेविट है ना R8 तो।
R8 और R9 लॉर्डशिप।
वो तो एफिडेविट्स हैं।
और इसके बेस पे लॉर्डशिप इन्होंने नगर पालिका से 2 मकान ले लिए, हाउस नंबर 36, 37, which I have annexed lordship at page annexure R10, page 41. इन्होंने एक खाली करने की बिना पे 2 मकान ले लिए सर,
देखा
और वो मकान ये एंजॉय कर रहे हैं।
नहीं मिले।
अरे रुक जाइए, RHSDP योजना के तहत महारानी इतना 16 में निर्मित आवासों
पेज 41 लॉर्डशिप,
अब पेज 41 ही पढ़ रहे
लॉर्डशिप।
हितग्राहियों की अंतिम सूची अनुसार दीपक जैन पिता इतना को 8वीं लॉटरी सिस्टम से आवंटित आवास का कब्जा सौंपा गया था। आपके द्वारा एक मुश्त राशि 25,000 रुपए में जमा किया गया है। शेष राशि 95,000 रुपए आप प्रति माह 1,000 रुपए के रूप में नगर पालिका में जमा कर रसीद प्राप्त करेंगे। आपके द्वारा प्रस्तुत आवेदन के अनुसार आवेदन का आवंटन निरस्त करते हुए आपको आवास क्रमांक 36 आवंटित किया जाता है।
चेंज किया लॉर्डशिप।
यथावत रहेंगे।
हाँ, चेंज ऑफ हाउस हुआ लॉर्डशिप, दूसरा अलॉट हो गया था। इसी प्रकार ब्रजेश शुक्ला को लॉर्डशिप दिया इन्होंने, वो 42 पे
हमारे सामने है ही नहीं ना।
नहीं है, इस पिटीशन नंबर 2 है वो सर।
अच्छा, पिटीशन नंबर 2 है।
लॉर्डशिप 42 पे है सर लॉर्डशिप वो। एंड लॉर्डशिप द कंडक्ट ऑफ द petitioner lordship, abrogate and reprobate is not applicable in this proceeding lordship. They have enjoyed the fruits saying that give us 10 days time, we will evict it, and the reply they are filing before SDM is that we are not the owner lordship, and in this affidavit they have clearly admitted that we are the owner, we are the landlord, और हम जो है 10 दिन में खाली कर देंगे। इन्होंने उसकी बिना पे 2 मकान ले लिए लॉर्डशिप। There are the 3 judgments of Supreme Court lordship which says there should not be abrogate and reprobate in the same proceeding. Proceeding before the SDM and municipality, they were very humble. We are very poor lordship. We don't evict us. Within 10 days, we will evict it. And now they are saying that I'm not the owner. I'm not the landlord. So abrogate, reprobate, Supreme Court again and again has said should be discarded in the same proceeding.
The party submits that petitioners are taking contradictory stands one after another. Full stop. It is submitted that before the sub-divisional officer, the stand of the petitioners was that the present respondent is not a landowner and he is not taking rent for last 19-20 years, and thus by way of adverse possession they have perfected their title as landlord. Full stop. On the other hand, they filed affidavits before the chief municipal officer seeking 10 days time to vacate the dilapidated structure. Full stop. It is also pointed out that the petitioners number 1 and 2 have obtained allotment of houses under the IHSDP project in Maharani Lakshmibai Ward, Bhatia Tola, from the municipality of Narsinghpur, as is evident from annexure R110 and R110, which are allotment letters dated 24/7/2017। क्या डेट है इसकी?
इसकी डेट लॉर्डशिप 24/7/2017,
24/7/2017, whereby they were given allotment orders for house number 36 and 37 after changing the earlier allotment for house number 249 and
only 249,
respectively.
250.
Full stop. Thus, it is submitted that petitioners are involved in the process of appropriate and reappropriate, which is not permissible in terms of the law laid down by Supreme Court in Prahlad Singh versus Colonel Sukhdev Singh, AIR 1987 SC 1145. In case of Jasraj Inder Singh versus Hemraj Multan Chand, AIR 1977 SC 1011 and AIR 1960 SC 941, in Satyadhyan Ghoshal and others versus Dev Ranjan Devi and another. Next para. After hearing learned concepts for the parties and going through the record, there is no dispute that the act of the sub-divisional officer is not is to be examined in the light of the judgments of this High Court, Kerala High Court, and Bombay High Court. Full stop. When these acts are examined, when these judgments are examined vis-a-vis act of the subdivisional officer, then in case of Virendra Kumar Maheshwari Supra, coordinate bench of this High Court has held that for the purpose of passing an order under section 133, comma, on receiving a report, the evidence is required to be taken as thought fit by the authority. Full stop. In fact, it is an integral part and mandatory requirement of section 133 of Criminal Procedure Code, comma. However, even for passing preliminary order, the procedure has to be followed. Next para. Thereafter, it is held that an opportunity has to be given both to the prosecution to prove the allegations so leveled against the petitioner and to the petitioner an opportunity to cross-examine on the prosecution witnesses. Full stop. It is further held that for want of such opportunity, comma, the acts of the subdivisional officer will be vitiated. Next, in case of Devki Amma, it is held that attempt of the party to evict the tenant from his tenanted premises, comma, the order for which should be obtained under the provisions of the relevant law. For the present case, it will be the Land Accommodation Control Act. Full stop. In para 12, it is held that report prepared behind the back of the parties, and when notice of inspection was not given to either of them and the building was closed at the time of inspection, PW2 did not even enter the building, then such act cannot be said to be justified. Next, in para 13, in case of Devki Amma itself, referring to the judgment in case of TKSM Kalyan Sundaram versus Kalyani Ammal 1975 CRLJ 1717, Madras High Court observed that Section 133 is attracted only in cases of emergency. This was approved by the Supreme Court in Vasant Manga Nikumba and others versus Babu Rao Bhikanna Naidu 1995 SUPP within bracket 4 SCC 54, when Supreme Court held that the dangerous condition of building is in present time but not in future, and read full stop. In case of K. Harilal, Kerala High Court observed that the principle that can be culled out from the decision in case of Jose V. Tharayal versus Revenue Divisional Officer 2010 bracket में 2 bracket close KHC 217 bracket में SN is that the jurisdiction provided under section 133 CRPC is confined to public right only. It is pertinent to note that the cardinal principle that the first respondent gets power under section 133 CRPC only if a public right is involved has been totally lost sight of. Full stop. Next para. Bombay High Court in case of Shri Peter Fernandez noted judgment of Supreme Court in Kachru Lal Agrawal Kacharulal, Bhagirath Agrawal and others versus State of Maharashtra and others 2005 9 SCC 36 and has held that section 133 of the code as noted above appears in chapter 10 of the code which deals with maintenance of public order and tranquility. Full stop. It is part of the heading within inverted commas public nuisance inverted commas close. The term nuisance ये फिर inverted commas as used in law is not a term capable of exact definition and it has been pointed out the exact definition. Full stop. Thereafter, it is held that proceedings under section 133 of the code are not meant to settle private disputes between two members of the public or members of two households and for public authorities to waste their time in trying to settle such disputes. A magistrate under section 133 of the code exercises a public duty and he can exercise it only when jurisdictional facts are present. There were none present in this case, are taken into consideration, then there is no iota of doubt that subdivisional officer was acting in excess of his jurisdiction. Full stop. He was trying to settle a private dispute and was acting as a middleman between the landlord and the tenant and was permitting a shortcut to be used by the landlord for seeking eviction of his property tenant. Next paragraph. However, when reply furnished by the petitioners before the subdivisional officer as is contained in Annexure R111 is taken into consideration, which has not been denied by filing any rejoinder, so also the affidavits which are part of the record as Annexure R18/R19, which though orally denied by Shri Ankit Saxena, but not denied in writing by filing any rejoinder, are taken into consideration, then it is evident that, and when they are read with the allotment letters issued by the municipality of Narsinghpur in favor of the petitioners, which according to Shri Tripathi are the letters of allotment of immovable property on the strength of rented property being in a dilapidated condition, are taken into consideration, then even right of the petitioners to continue in the said building which is admittedly in a dilapidated condition cannot be upheld. Full stop. Petitioners cannot take contrary stands as has been discussed by Supreme Court in Satyadhyan Ghoshal and others supra, wherein it is held that a party is required to take one stand and is not permitted to appropriate and reappropriate as per his convenience. Full stop. In the present case, on the one hand, petitioners claim that they are not the tenants of the private respondent, as is evident from the reply filed by them before the subdivisional officer, and then on the other hand, before the High Court, they take a plea that they, being tenants, can only be asked to vacate the suit premises only by resorting to procedure of eviction as provided under the Accommodation Control Act. Full stop. This stand of the petitioner reflects on their intentions and clearly makes out that they have not approached the court of equity with clean hands. Full stop. Thus, a party who is seeking indulgence of the High Court in its equitable writ jurisdiction fails to approach the High Court with clean hands and approbates and reapprobates about its stand and after having already taken a benefit on the ground of property being in a deliberated condition, and thereafter seeking allotment of houses from the municipality under the IHSDP scheme, then it is not open to them to assail the order on merits, full stop. Next para. Thus, to conclude, this court is of the opinion that subdivisional officer exceeded his jurisdiction. He acted as an agent oblique middleman for the landlord without, and therefore in the light of the judgment of this high court in Virendra Kumar Maheshwari Supra and that of Bombay and Kerala High Court, वो नाम डाल लीजिएगा, इतना Supra, comma, SDO had no authority to order for eviction. Therefore, that order being not maintainable in the eyes of law is hereby set aside. Next para. However, setting aside of that order will not grant any direct and substantial relief to the petitioners who have already obtained an order of allotment of another house which is available on record on the pretext of the rented accommodation being in a dilapidated condition. Therefore, they are liable to evict the property to be handed over to the landlord for demolition of the said property, full stop. It is made clear that no repairs will be permissible in the suit property and it will be demolished and further actions will be taken in accordance with law. Full stop. A demolition report will be furnished to the CMO within 15 days of receipt of certified copy of the order.
After Diwali. After Diwali.
15 दिन में दिवाली हो जाएगी ना? अच्छा, 30 दिन कर दीजिए, चलिए 30 डेज कर दीजिए, चलिए, और ये भी 30 डेज में पोजीशन देंगे, ठीक है, चलिए,
I'm obliged, Lordship.
हाँ तो हो गया आपको,
Obliged.
क्या है लॉर्डशिप 30 डेज का दिए ऐसा
है?
कि वो
क्या हो गया?
ही इज आस्किंग 30 डेज से ज्यादा
दिवाली तो कराने,
नहीं
ठीक है,
इवन 11 तक कर ले सर, हमें कोई दिक्कत नहीं है, बट
30 दिन हो गया ना, बस ठीक है,
आई एम ऑब्लाइज्ड.
आपको वापस करो, क्या करना, इन अबव टर्म्स petitions are disposed of. ये मैडम का शुभ नाम बताइए, क्या नाम है मैडम आपका? लिख लिया ना, ठीक है,
Yes, sir.
हाँ,
साक्षी बात.
एसडीओ पे कॉस्ट लगा दें आपके, फॉर एक्टिंग एज अ मिडिलमैन कॉस्ट लगा देना एसडीओ पे 10,000 रुपए की, टू बी पेबल टू बी पेड इन द डिस्ट्रिक्ट लीगल सर्विसेज अथॉरिटी टू बी यूटिलाइज्ड फॉर द वेलफेयर ऑफ द पुअर litigant. District Legal Service Authority, Narsingpur. He will furnish a receipt of depositing such cost within 15 days from his own, out of his own pocket before the registry of the High Court, which will place it before this court for perusal.
Actually, airing officer.
Huh?
Airing officer.
Airing only, SDO will deposit it and will be free to recover it from the airing official who passed the impugned order.
Lordship.
Chaliye.